Jefferson County Court at Law number 2 is back in session and calls number 331-264. Case is styled the state of Texas versus Jonathan Bozeman. Jonathan Bozeman is appearing via Zoom. Jonathan Bozeman was previously sworn in. Jonathan Bozeman is represented in this case by his attorney, Attorney Giles Cole, who waived the record in Mr. Bozeman's case. Mr. Bozeman entered a plea of no contest to the charge of indecent assault as alleged in the information. Mr. Bozeman acknowledged that his initials were on page 2 of the misdemeanor plea admonishment. He also acknowledged that his signature was on page 3 of the misdemeanor plea acknowledgement, which is also State's Exhibit 1. Now, Mr. Bozeman, I'm going to show you a document that is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant?
Yes, sir.
And there are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Mr. Bozeman, did you also sign a document on paper that is titled Discovery Certification?
Yes, sir.
Now, Mr. Bozeman, before you signed and initialed all of these documents that I have just mentioned to you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Bozeman, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment, and State's Exhibit number 2, the probable cause affidavits, which is in the court's file. State, you like to offer State's Exhibits 1 and 2?
Yes, Your Honor. State offer stage 1 and stage 2.
Any
No
objections?
objection.
No objection. State's Exhibits 1 and 2 are admitted. Mr. Cole, you've advised and counseled Mr. Bozeman. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Bozeman, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Bozeman, I will accept your plea of no contest, your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that plea bargain agreement?
Your Honor, in exchange for the defendant's plea of no contest in this case, the state is recommending confinement in the Jefferson County Jail for a period of 90 days, Your Honor. We're asking that the defendant receive credit for all time to which he's entitled by law.
Mr. Bozeman, the state is offering that you serve 90 days in the Jefferson County Jail. You will be given credit for any time that you are entitled to get by law. The court cost in this case is $327. Mr. Bozeman, will you be able to pay the $327 today?
No, sir.
Mr. Bozeman, do we have an actor? I have before me a document that is titled Affidavit of Indigence. And Mr. Giles Cole, pursuant to Article 1.24 of Texas Code of Criminal Procedure, all trials and proceedings are to be held public. However, pursuant to Lilly versus State, 365 Southwest Third, 321. The right to a public trial is not absolute and may be outweighed by other competing interests, such as interest in security, preventing disclosure of non-public information, or ensuring that the defendant receives a fair trial. Mr. Cole, the information that I have some questions that I need to ask your client. Are you requesting that this hearing be closed to the public to prevent the disclosure of non-public information?
Yes, sir.
The court finds that the party seeking to close the hearing have advanced an overriding interest that is likely to be prejudiced to the defendant in that it will disclose non-public information. The closure is no broader than necessary to protect the defendant's interest. And the trial court have considered or has considered other reasonable alternatives. And the court finds that it is adequate, or actually the court findings are adequate to support